Okay, let's dive in. Natural law. It's one of those phrases, isn't it? It can bring up some really strong feelings.
Definitely. It's got this incredibly long history, but then it suddenly bursts back into public view, like, remember the Clarence Thomas hearings our source mentions?
Exactly. And the reactions are all over the place. For some people, it's this pure source of truth and justice. For others,
Ah.
well, our source has some pretty striking descriptions.
Yeah, like talking about it is like mentioning torture by thumbscrews.
Or alchemy, or my favorite, showing up at the airport in a Hare Krishna robe.
Huh. Yeah, really vivid stuff. It signals just how much distrust and, frankly, confusion surrounds the whole idea.
Right. So that's our goal for this deep dive. We're using Philip Soper's article, Some Natural Confusions About Natural Law, to try and cut through all that noise. We want to unpack what natural law actually is, figure out why it's so confusing for so many people, and understand what's really going on in these debates. Really help you, our listener, get a much clearer handle on it.
And it's worth noting, the very fact that these ideas keep sticking around for centuries. I mean, scientific theories come and go, right? They get outdated. But natural law concepts persist. It suggests they're tapping into something pretty fundamental about, how we think about morality and law.
That's a great point.
And our source, Soper, his whole aim is clearing up misunderstandings. He calls them natural confusions, which is interesting
Natural confusions, why natural?
because they often have understandable roots, historically or logically. And, maybe surprisingly, he points out that sometimes it's the advocates of natural law themselves who actually help perpetuate these confusions.
Okay, that is interesting. The theory tripping over its own feet, in a way. So where does the confusion start? What's the first big one the source tackles?
The first major point is that the term natural law is actually used for two quite different things. It gets used as both a moral theory and as a legal theory, and people often conflate them.
Okay. Two different jobs for one term. Can you break those down for us?
Sure, so natural law as a moral theory. That's the older idea, really. Goes way back to classical philosophy, Greek and Roman thinkers, and then through medieval theology, like Thomas Aquinas. The basic idea here is that there are objective moral truths. They're not just opinions or conventions, they're real, and we can figure them out using reason. Often the thought is by reasoning about human nature itself, a bit like discovering the laws of physics.
Discovering morality, like discovering gravity. Okay.
Right. But, as the source notes, this idea of objective morality isn't unique to natural law. Other theories, like utilitarianism or Kantian ethics, also claim morality is objective, so that adds another layer.
Okay, so natural law, moral theory is about objective, discoverable moral truths. What about the legal theory side?
Natural law as a legal theory that really takes shape in contrast to something called legal positivism.
Right, legal positivism. That's the idea that law is just what the authorities say it is, basically,
Well,
regardless of whether it's fair or just.
pretty much. Legal positivism claims there's no necessary connection between what the law is and what morality says it should be. You can identify the law based on its source who made it, the process, without making a moral judgment about it. A natural law legal theorist pushes back against that. They deny that sharp separation. They argue there is some kind of essential link between law and morality.
Okay, so we have objective morality on one side and the law morality connection on the other. Now, the source says it's not actually obvious these two ideas have to go together. Is that right?
That's exactly the point. Logically, you could accept objective morality be a natural law moral theorist, but still think law is just about social facts and sources be a legal positivist, or, vice versa.
Huh. But they do often seem linked in discussions. Why is that if it's not strictly logical?
Well, the source digs into a few reasons why they've become historically entangled. One is just historical context and misinterpretation. Think about Aquinas again. He quotes Augustine saying, "A law that is not just seems to be no law at all." It sounds like a direct link, right?
Yeah, sounds like unjust law isn't legally valid.
But the source argues Aquinas was really talking about moral obligation. He meant an unjust law doesn't bind in conscience. It doesn't create a moral reason to obey. And interestingly, most legal positivists today would actually agree with that moral point. They separate identifying the law from the moral question of whether you should obey it. The famous Hart-Fuller debate touched on this.
So Aquinas was maybe making a moral point, not a legal definition point, and we've kind of run with the wrong interpretation.
That's the argument. And there's a linguistic issue. The word law itself is slippery.
How so?
We use it for scientific laws, like laws of nature, objective facts. And we use it for human laws, rules made by human will, by fiat. Classical thinkers use the natural law analogy for objective moral truth, like scientific laws. But mixing that with law as human commands, it invites confusion, especially if a moral theory links morality to, say, God's will. It might mistakenly push people to think their moral theory requires rejecting positivism's focus on human will and defining human law.
Ugh, the word itself is doing double duty and confusing things. Okay, any other reasons?
There's also a potential conceptual leap. Natural law, moral theory, often stands against the idea that morality is just convention, just what society agrees on. And since legal positivism often describes law as a kind of social convention, well, someone might think, if I oppose conventional morality, I must also oppose conventional law.
But the source says that's a leap.
Yeah, you can logically say law is based on convention, but morality isn't, without contradicting yourself. They are separate claims.
Okay, so historical interpretation, the word law itself, maybe some fuzzy thinking. These explain the link, even if it's not logically required.
Exactly. And the source even floats the idea of a sort of strategic motivation.
A hidden agenda.
Kind of. Maybe a moral theorist who deeply believes morality is objective pushes the legal theory, saying unjust directives aren't law, as a strategy. It forces people to confront the idea of objective standards for justice.
So using the legal argument to advance the moral one.
Potentially. But the source calls that more psychological or strategic, not a logical necessity flowing from the moral theory itself. Other moral theorists could use the same tactic.
Right. Is there any point where the two theories might genuinely connect, according to the source?
So Bobber does raise one possibility, kind of deeper point of contact. Maybe the difference lies in what we assume law is fundamentally for even before we start analyzing it.
What do you mean?
Maybe positivists just think law is about rules that guide behavior, full stop. Whereas maybe natural lawyers think law inherently claims to create moral obligations. It claims a kind of fidelity, like Lon Fuller argued against Hart.
Okay. So if law frames moral authority.
Then maybe legal theory does need to engage with moral theory to see if that claim can be justified. But the source quickly adds, even if that's true, it doesn't automatically mean a natural law moral theory is the only way to justify it.
Got it. So even the potential links are pretty subtle and contested. It really sounds like keeping the moral theory and the legal theory distinct in our minds is crucial here.
Absolutely. The historical entanglement seems more powerful than the logical connection based on this analysis. Maybe it's best seen as a sympathetic partnership sometimes, both arguing for objectivity, but not necessarily logically dependent.
Okay, let's pivot slightly. You mentioned those really visceral reactions earlier, the thumbscrews comments. Let's talk about the skepticism towards natural law as a moral theory itself. Why does it make people so uneasy beyond the structural confusions we just discussed?
Well, a big part of it, as the source points out, is definitely the historical connection to religion.
Right, you mentioned Aquinas and theology earlier.
Exactly. For much of its history, natural law was deeply intertwined with finding moral truth in God's will or divine revelation, particularly within Catholic thought. So if you don't share that specific faith or believe moral truth comes from revelation, you're naturally going to be wary when someone starts talking about natural law. You might suspect it's religion disguised as reason.
And the source mentions this came up in the Thomas hearings, whether his views were religious or secular.
Precisely. It shows how that association lingers and creates immediate suspicion for many people. Is this based on reason everyone can access, or faith only some share?
Makes sense. What about the secular versions, though? The ones based just on reason? Do they escape this skepticism?
Not entirely. The source points to a different kind of problem that can arise there. The feeling of self-righteousness or appeals to self-evidence.
How does that work?
Well, if a secular natural law theory says its core moral principles are just self-evident, discoverable by reason, what happens if someone doesn't find them self-evident?
They might feel like they're being called stupid or worse, immoral.
Exactly. It can come across as dismissive, like the proponent thinks they have special access to obvious truths that others are just missing, willfully or otherwise. It can feel, as the source suggests, like a kind of secular stand-in for claiming divine insight.
Which understandably rubs people the wrong way.
Right. It leads to that perception of self-righteousness, which fuels skepticism just as much as the religious connection does for others.
So it sounds like a lot of the pushback isn't necessarily against the idea that there might be objective moral truths knowable by reason,
Probably not, at its core.
but more a reaction to how it's been historically tied to religion or how some proponents argue for it. maybe making claims of obviousness that shut down discussion.
I think that's a fair summary of the source's point here. These are often reactions to specific versions or specific advocates, not necessarily a knockout blow against the whole project of objective ethics. Any objective theory has to explain how we know what's true, and that's always a challenge.
Okay, that clarifies the skepticism around the moral theory. Let's switch back to the legal theory side and what the source calls the natural law dilemma. This seems to connect directly to those fears about judges.
Yes, the concern during the confirmation hearings was often framed as, could a judge use natural law to ignore or override the written law, like the Constitution or statutes?
And both Judge Thomas and Senator Biden seem to agree that shouldn't happen.
They did, publicly at least. They agreed that natural law shouldn't be a basis for reaching a result, clearly inconsistent with the positive law. The worry was this idea of a higher law trumping actual legislation.
But the source says this gets confused with something else.
Yeah, it often gets tangled up with the interpretivism debate. That's the whole question of how judges should interpret laws that are already vague or use broad moral language.
Like due process or maybe the Ninth Amendment suggesting unenumerated rights.
Exactly. Some argue that interpreting those parts requires judges to look to fundamental moral principles. That was sort of Biden's position. And Thomas also nodded to the framers using natural law ideas. But the source's key point is that this debate, whether the Constitution itself directs judges to consider morality in some cases, is separate from the core natural law versus positivism debate about the definition of law.
How so?
Because, ironically, maybe the strongest argument for judges using moral reasoning to interpret vague clauses can be a positivist one.
Really?
Well, a positivist like H.L.A. Hart would say, if the positive law itself, the text enacted through the proper process, uses moral terms or points to moral standards, then applying the law correctly requires moral reasoning. It's the law telling you to do it.
Ah, so it's not necessarily natural law overriding positive law. It could be positive law incorporating moral considerations.
Precisely. The source mentions an exchange about the Lochner era, often criticized as judicial activism based on natural law ideas. But the real debate might be how judges interpreted the Constitution's terms then, working within the positive law framework, not necessarily invoking a separate higher law against it.
Okay, so interpreting vague laws using morality isn't the core issue that separates natural law and positivism in legal theory. What about the original fear, then, a judge just flat out ignoring a clear law because they think it's deeply immoral?
Here the terminology gets really interesting, as the source points out. A strict positivist who completely separates law and morality. They might actually be more likely to say a judge facing a truly evil but clear law might have a moral duty to refuse to apply it.
Why?
Because the positivist says, yes, this is legally valid according to our system's rules, but it's morally abominable, so morally I should resist. They keep the legal identification separate from the moral judgment.
Whereas the natural lawyer says.
And the natural lawyer might say, because this is so unjust, it's not truly law at all, so I'm not even legally bound to apply it. It collapses the legal and moral.
So the question of whether a judge should apply a wicked law, that's not really settled by choosing between natural law and positivism as your legal theory?
Not directly, according to the source. It becomes a question of political morality, what's the judge's role, their oath, the consequences.
Yeah.
That's a separate domain from the theoretical definition of law.
Okay, so if it's not really about interpretation and it's not directly solving the judge's moral dilemma with wicked laws, what practical difference does adopting a natural law legal theory make? This brings us to the dilemma, right?
Exactly. What's the point? The source suggests natural law theorists want to embed the moral evaluation inside the concept of law. So, doing justice isn't something judges do despite the law sometimes. It's part of fulfilling their legal role, because unjust directives don't count as law. But here comes the natural law dilemma, as Soper frames it. Natural law insists that mere human convention or decision fiat, the fact that someone in authority declared it so, isn't enough. Law needs moral grounding.
Okay, makes sense. So what's the problem?
The problem is, who in the real world gets to decide what true morality requires and whether a law meets that standard?
Uh-oh. Humans, right? Judges, legislature.
Oh, God, humans. So you need human institutions to apply these supposedly objective moral standards to the law. And their decisions, however well-intentioned, are themselves a form of fiat. Their judgment becomes binding.
So you can't escape fiat.
Seems not. And that's the dilemma, either. One, the system ultimately relies on the fiat of these human institutions. Judges saying this meets the moral standard,
Hmm.
which makes natural law's protest against fiat seem kind of ineffective in practice. Or two, you say no human decision is truly binding if it conflicts with objective morality, which seems to push you towards anarchy, everyone deciding for themselves what the law really is based on their own moral compass.
Wow. So it's either practically irrelevant because fiat wins anyway, or it leads to chaos. That's a tight spot.
It is. It mirrors the classic charges. Positivism leans towards authorizing anything the state does, law is law, while natural law leans towards undermining legal authority altogether. Only just law is law.
So positivism emphasizes the necessary role of fiat, maybe downplaying morality's role in law's concept, while natural law emphasizes reason and morality, but struggles with the practical necessity of fiat for a functioning system.
That's a good way to put it. The source argues positivism focuses on the reality of human decision-making, leaving moral critiques separate, while natural law tries to integrate them, but then faces this implementation problem through fallible humans.
Does the source look at how recent natural law theories try to handle this?
Yes, and it argues they often still fall into the dilemma. For instance, seeing natural law as a theory of adjudication. The idea may be associated with thinkers like Dworkin that judges must engage in deep moral reasoning to decide cases correctly.
That sounds like incorporating morality. What's the issue?
The source says this just shifts the unavoidable fiat from the legislature to the judge. The judge does their moral reasoning, reaches a conclusion, and that conclusion becomes legally binding because the judge decided it. It's still fiat. It's an argument about whose fiat is better informed, maybe, but not about escaping fiat itself.
It doesn't overcome the need for a final binding decision by someone.
Right. Legal realists made a similar point long ago. Law, in practice, is often just what the judges say it is. Their decision is the fiat.
Okay, what about other attempts?
Another approach is framing natural law as a call for individual conscience. The idea that ultimately no law or official decision can determine your true legal or moral duty, that's up to your individual assessment against objective morality.
That sounds potentially chaotic, like the anarchy horn of the dilemma.
Exactly what the source says. It pushes towards anarchy. And ironically, it almost sounds like the positivist goal of separating law, here's what the state demands, from morality. Now, you decide if you should obey. The key problem here, the source argues, is that this ignores the state's claim, a potentially justifiable claim, to enforce its laws based on its own good faith, even if fallible, attempt to achieve justice. The idea that fiat can have moral force even if the outcome isn't perfectly just.
So the individual conscience approach fails to account for the state's need to act and enforce decisions.
Right. It doesn't grapple with the justification for state authority itself.
Okay, so if these modern framings still get caught in the dilemma, is there a way out? What could a coherent natural law theory look like, according to Soper? How could it make a real difference without leading to anarchy or just being symbolic talk?
The source tries to sketch the parameters. A viable natural law theory would have to be about the limits of convention or fiat, limits on the state's claim to be justified in acting based on its own decisions.
Limits. Okay.
And crucially, these limits wouldn't just be abstract moral critiques. They'd need to be somehow recognized within the legal system itself, like official exceptions to the binding power of ordinary law,
Exceptions based on.
based on political theory about when state coercion is justified. When does the state lose its moral authority to enforce its decisions?
So connecting legal theory back to political theory about state legitimacy.
Exactly. The source looks at the state's claims. Claim 1. The state can punish you for breaking its rules, even if a rule is flawed, provided the system acted in good faith based on its understanding of justice at the time.
We did our best justification.
Right. And the source argues this claim is pretty strong. We need final decision makers to avoid chaos. And we generally accept that acting in good faith can justify actions even if mistakes are made, like wrongful convictions based on factual errors, or very hard cases like Korematsu. So fiat justifying action, including punishment, has a strong basis.
What's the other claim?
Claim 2. That you have a general moral obligation to obey just because it's the law. The source sees this claim as much weaker, less essential.
Okay, so focus on the first claim, the state's right to punish based on its good faith decisions. Where does natural law fit in?
Natural law's role, the source suggests, could be to define the limit to that first claim. It says the state's justification based on we acted in good faith according to our conventions breaks down when the content of the law or action is so profoundly unjust that the good faith excuse just isn't plausible anymore.
Like an injustice so extreme it overrides the process justification.
Precisely. An undeniable moral error that couldn't have been made in good faith by any reasonable standard. Think of laws mandating genocide or slavery.
So it's a threshold based on extreme injustice.
Yes. But importantly, even identifying when that threshold is crossed still requires a judgment call by fallible human institutions, so you don't fully escape fiat.
Right. Someone still has to decide, okay, this law crosses the line.
Exactly. Which means the practical effect of adopting this kind of natural law theory might be, in the end, largely symbolic.
Symbolic how?
It's building a reminder into the legal system itself. Our authority, based on our procedures and good intentions, is not absolute. It has outer moral limits. It's a constant signal that convention alone isn't the ultimate source of justification when fundamental justice is at stake.
Like the principles that emerged after WWII and Nuremberg, the idea that just following orders, or it was the law then, wasn't a sufficient defense for certain atrocities.
That's exactly the connection the source makes. Nuremberg represents a moment where the international community asserted that the justification for state fiat hits a wall when confronted with profound, undeniable injustice.
So the ultimate point of natural law, when you strip away the confusions, it might be this core idea that truly, deeply unjust laws lose their moral force to obligate us or justify punishment.
That seems to be where the source lands. Its persistence, despite all the theoretical tangles, might just come down to the simple, powerful truth of that idea. A truth demonstrated when systems based on convention produce results later recognized as morally indefensible.
Wow. That's quite a journey through the layers of confusion. We've separated the moral and legal strands, looked at why people get so skeptical of the history, the claims of self-evidence, and really wrestled with that core dilemma. How do you square objective moral truth with the practical need for binding human decisions for fiat?
Yeah, the source really drives home that tension. You need both reason figuring out what's genuinely right and fiat having mechanisms for making binding decisions in any workable legal system. The challenge for natural law is how to meaningfully integrate its focus on reason without undermining the necessary role of fiat.
And the suggestion is maybe digging deeper into political theory about when state power is justified is key to finding that balance.
That seems to be the implication. Understanding the limits of legitimate state authority might be where natural law finds its most coherent place.
Well, thank you. That really helped unpack a lot of complex ideas from the source material. It definitely cuts through some of the fog around natural law. So for you, our listener, maybe a final thought to take away from this, sparked by the source's conclusion. If the enduring value here is that profoundly unjust laws lack moral force, how do you determine that critical threshold? In a world where morality is often complex and disputed, where is that line where injustice becomes so undeniable that it overrides the system's claim to authority? And knowing that even the official judgments about justice within our legal systems are made by fallible people, what does that mean for how you relate to the law day to day? Just something to think about. This deep dive, as always, is just a starting point for your own reflections.